two parts. West Malaysia was once the independent country of Malaya. East Malaysia is made up of two former British protectorates, Sarawak and Sabah. Now they are two of the 13 states that make up West and East Malaysia.
We will now focus on Peninsular Malaysia as our topic concerns the legal framework of Malay Reserve Land in Malaysia.
Assalamualaikum and a very good day everyone. Today we will discuss Malay Reserve Land, MRL, a unique institution under the Malaysian land law that aims to preserve Malay ownership of land. The system originated from the Malay Reservation Enactment 1913 during British colonial rule to prevent Malay land from being transferred to non-Malays. However, in modern Malaysia, questions often arise regarding financing, development project and land transaction involving Malay Reserve Land.
Hello. Okay, so I own a piece of Malay Reserve land. Recently, I received an offer from a developer to build a housing project on my land.
That's right, the location is strategic and has good development potential.
But to proceed, I need financing from a bank.
Our bank can provide financing, but the land must be charged to us as security.
Wait a minute.
Malay Reserve Land give rise to several important legal issues. First, can Malay Reserve Land be effectively used as a security for bank financing despite the restriction imposed under the Malay Reservation laws? Second, who qualifies as a Malay for the purpose of dealing with Malay Reserve Land and why does the definition differs from one state to another? And third, can companies with non-Malay shareholders legally acquire or develop Malay Reserve Land? To answer this question, we must first examine the legal framework governing Malay Reserve Land.
There are several important laws govern Malay Reserve Land. First is Federal Constitutions. Article 89 of the Federal Constitution protects the Malay reservations. It also requires replacement land where Malay Reserve Land is revoked. The second one is National Land Code 1965. The NLC governs land dealing. However, Section 4, Subsection 2 states that where there is inconsistency, Malay reservation laws prevail over the National Land Code. The third one is Malay Reservation Enactments. The various state enactments generally prohibit the transfer of Malay Reserve Land to non-Malays and regulate who may own or deal with such land. And lastly is Housing Development Act 1966. The Housing Development Act regulates housing developers and protects home buyers.
To understand Malay reservation laws in practice, we examine four important Malaysian cases.
What happens if Malay Reserve land is transferred to a non-Malay?
That issue arose in Haji Hamid and Ahmad Mahmud. In this case, Malay Reserve Land was transferred to a non-Malay despite the restriction imposed by the Malay Reservation Enactment. However, the court rejected this argument and held that the transfer was ab initio, meaning void from the very beginning.
This case established an important principle. Any transaction that violates Malay reservation laws is invalid regardless of the intention of the parties.
But what if the transaction has already been registered under the NLC? That was the issue in Badiadian and Arab Malaysian finance. Normally, registration grants a registered proprietor an indivisible title under the NLC. However, the court held that when transaction contravene Malay reservation laws, registration cannot cure the illegality.
The significance of this case is that the protection of Malay Reserve Land can override ordinary land registration principles where necessary.
Malay Reserve Land cannot be used as security. How can landowners obtain financing?
The federal court addressed the issue in Affenberg and Zamanuddin. A Malay owner had charged his Malay Reserve Land to Affenberg as a security for a loan. The federal court disagreed. The court held that the charge does not transfer ownership of the land. Instead, it merely creates a security interest in favor of the bank.
This decision is significant because it allows Malay landowner to obtain financing while still preserving Malay ownership of the land.
If the land administrator refuses to register a transfer because he believes the applicant is not Malay?
That issue arose inside Syahrul and Pentadbir Tanah Daerah Kelang. The applicant sought to acquire Malay Reserve Land and create a charge in favor of an Islamic financial institution. The High Court examined the evidence and found that the applicant's birth certificate officially recorded him as a Malay. The court held that the land administrator could not disregard official records without proper legal justifications.
This case is important because it clarifies the definition of a Malay under the relevant enactment and promotes fairness in an administrative decision-making.
From these four cases, we can observe a clear development in judicial thinking, while the courts remain firm in protecting Malay ownership of the land. From these cases, three practical applications that can be identified. Application 1. Malay Reserve Land can still be used as a security for financing, allowing Malay owner to access credit and develop their land. Application 2. Land administrator must make decision based on proper evidence and statutory requirement. And application 3. Developers, companies and landowner must strictly comply with the Malay reservation laws because courts will invalidate any transaction that attempts to circumvent statutory restriction. In our opinion, the courts have adopted a balanced and practical approach by preserving the protective purpose of Malay reservation laws while allowing Malay Reserve Land to remain economically productive.
Although the courts have recently adopted a more practical approach towards financing involving Malay Reserve Land, significant challenges still remain.
What kind of challenges?
The first challenge is known as the economic valuation gap. Studies have shown that Malay Reserve Land is often valued 30% to 50% lower than comparable non-reserve land because its transfer and ownership are restricted to Malays.
The second issue involves Article 89, Clause 3 of the Federal Constitution.
Isn't that the provision requiring replacement of land?
Exactly. Whenever Malay Reserve Land is revoked for public projects, the state authority is constitutionally required to replace it with another parcel of land of equivalent size and character. However, reports and policy debates suggest that some states have not consistently complied with this 1:1 replacement requirement.
Another important development concerns financing. Recent judicial decisions, such as in the case of Syed Shahrul and Afin Bank, demonstrate a growing willingness by Malaysian courts to adopt a purposive interpretation of Malay reservation law. Courts have recognized that charges in favour of licensed financial institutions can be allowed, provided that Malay ownership remains protected.
Based on these developments, we propose 3 recommendations. First, state authorities should strengthen monitoring and enforcement of the Article 89 Clause 3 replacement requirement. Second, Malay reservation laws across different states should be harmonised. Third, clearer statutory provisions should be introduced to expressly regulate modern financing mechanisms involving licensed bank and Islamic financial institutions.
Conclusion, Malay reservation land continues to play a vital role in protecting Malay ownership in Malaysia. However, modern economic realities require the law to strike a balance between preservation, financing and development. Through the cases we discussed today, we can see how Malaysian courts have attempted to maintain this balance while upholding